Have you ever wondered how deeply untouchability affects our society? It's a question that, unfortunately, remains pertinent in our times. Untouchability, a social evil deeply rooted in prejudice and discrimination, continues to leave a bitter mark on our society. This video aims to delve into this issue, providing a comprehensive understanding of untouchability, its legal aspects, and its societal impact. In this video, we will explore the concept of untouchability, its legal aspects, and its social impact. Untouchability, a complex term, is more than just a word. It's a social phenomenon deeply rooted in the annals of history, with its tendrils reaching far into the fabric of societies across the globe. Originating from the caste system of ancient India, untouchability refers to the practice of ostracizing a group by segregating them from the mainstream on the basis of their birth into a certain caste. This group, deemed untouchables, were relegated to the margins of society, forced to perform menial tasks, and denied access to common public facilities. Over centuries, this practice became so deeply ingrained in societal norms that it was often overlooked as a form of discrimination. Untouchability is not simply about physical touch or proximity. It's a system of subjugation, a tool of power and control that perpetuates social inequality on the basis of birth. Untouchability, hence, is not merely a practice but a deep-seated social evil. The Indian Constitution, in its pursuit of equality, has outlawed untouchability in Article 17. This provision is a cornerstone of the Constitution, reflecting the nation's commitment to eradicate this inhumane practice and promote social equality. Article 17 reads as, "Untouchability is abolished, and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law." This language is clear, firm, and leaves no room for ambiguity. It unequivocally bans the practice of untouchability in all its forms. The intent behind including Article 17 was to dismantle the age-old social hierarchy that had been deeply ingrained in Indian society. This caste-based discrimination was not only socially divisive, but also fundamentally inhumane, denying a section of the population their basic human rights and dignity. Article 17 is not just a legal provision, but a symbolic gesture, an acknowledgement of the wrongs of the past and a commitment to rectify them. It was a message to those who had been ostracized and marginalized for centuries, assuring them that the new India would not tolerate such discrimination. The brilliance of Article 17 lies in its simplicity. It does not delve into specifics or exceptions. It simply declares untouchability an offense, punishable by law. This broad approach was necessary to ensure that the law could adapt to the various forms and manifestations of untouchability, which are often subtle and covert. It's also important to note that Article 17 is an absolute right, meaning it cannot be suspended or revoked under any circumstances. It is a testament to the firm resolve of the framers of the Constitution, who were determined to eradicate this social evil once and for all. In essence, Article 17 is a beacon of hope, a promise of equality. It was a bold step in the journey towards creating an egalitarian society, where every individual, irrespective of their caste or social status, is treated with equal respect and dignity. Therefore, Article 17 stands as a beacon of hope, a promise of equality to all. The law is not merely a written text, it carries consequences. Indeed, when it comes to the practice of untouchability, the repercussions are severe, reflecting the commitment of the Indian Constitution to eradicate this social evil. The Indian Penal Code, under various sections, penalizes acts promoting untouchability. For instance, Section 153A prohibits promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony. Section 295A also penalizes deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs. Moreover, the Protection of Civil Rights Act 1955 further strengthens the legal framework against untouchability. It criminalizes the enforcement of any disability arising from untouchability and prescribes punishment ranging from a month to 6 months of imprisonment, a fine, or both. The Act also empowers the government to impose collective fines on inhabitants of an area where such offences frequently occur. Furthermore, the Scheduled Castes and Tribes Prevention of Atrocities Act 1989 provides for stringent punishment for offences relating to untouchability against members of scheduled castes and tribes. It also establishes special courts for the trial of such offences and the rehabilitation of victims. The law thus sends a clear message: untouchability will not be tolerated. Court judgments often serve as landmarks in the fight against untouchability. One such groundbreaking judgment was the Kerala High Court's decision in the case of Mahadu S. O. Manjappa v. State of Kerala. The court here emphatically stated that untouchability in any form is a punishable offence, thus setting a significant precedent. In another landmark decision, the Supreme Court in the case of People's Union for Civil Liberties vs. Union of India reiterated the importance of ensuring dignity and equality for all citizens. The court held that untouchability, even under the guise of tradition, was unconstitutional. Moreover, the Madras High Court in the case of Perumal vs. Ponusami underlined that the right to live with dignity, free from untouchability, is an inherent part of the right to life under Article 21 of the Constitution. These judgments underline the judiciary's commitment to eradicate untouchability. They serve as a beacon of hope, reminding us that the fight against this social evil is both ongoing and necessary. Implementing laws is a challenging task, more so in the case of untouchability. The path to a discrimination-free society is often strewn with obstacles. Let's delve into some of these challenges. Firstly, the social challenge. Untouchability, unfortunately, has deep roots in the Indian society, making it a difficult social evil to eradicate. Even though the law clearly prohibits it, the practice persists in many remote and rural areas. Changing ingrained societal beliefs is a Herculean task and requires sustained efforts over a long period. Secondly, the bureaucratic challenge. The implementation of laws against untouchability requires the active participation of the entire bureaucratic machinery. However, the lack of awareness, indifference, or sometimes a biased mindset may hinder the process. Ensuring unbiased law enforcement is a challenge that needs to be addressed. Lastly, the legal challenge. Although Article 17 outlaws untouchability, the lack of a clear definition of what constitutes untouchability in the Constitution often leads to legal ambiguities. This, combined with the slow pace of judicial proceedings, can sometimes result in delayed justice. So, it's evident that the road to implementing Article 17 is a challenging one, filled with social, bureaucratic, and legal hurdles. But remember, no mountain is too high to scale, no river is too wide to cross, and no problem is too big to solve. Overcoming these challenges is crucial to ensuring the effective implementation of Article 17. Untouchability, though illegal, continues to have a significant social impact. It's a ripple that extends far beyond the individuals directly affected by it, influencing various aspects of society. Untouchability is not just a legal issue, but a social one that impacts how people interact, form relationships, and view each other. It holds a mirror to our society, reflecting the deep-seated biases and prejudices that still persist. It's a barrier that divides, creating a chasm between people based on their birth and not their worth. In the realm of education, untouchability rears its ugly head, stifling potential and curbing opportunities. It's a roadblock that prevents many from accessing quality education and realizing their full potential. The repercussions are not just individual but societal, as we lose out on the contributions these individuals could make. Similarly, untouchability affects economic opportunities. It's a chain that binds, limiting the job opportunities available to those deemed untouchable. This economic marginalization perpetuates the cycle of poverty, adversely impacting not just the individuals but the economy as a whole. Untouchability, thus, is a social malaise that permeates various aspects of society, hindering progress and fostering inequality. It's a wound that needs to be healed, not just for the sake of those directly affected by it, but for the overall health and progress of our society. The social impact of untouchability thus extends far beyond the practice itself. Untouchability, despite being outlawed, remains a pressing issue. We've traversed the historical and legal landscape of this social evil, from its definition to the constitutional provision of Article 17 that seeks to abolish it. We've delved into the legal ramifications, highlighting the significant judgments that have shaped the fight against untouchability. Our journey took us through the intricate maze of implementation and the formidable challenges that persist. In an ideal world, laws on paper translate seamlessly into practice, yet we know that's not always the case. The social impact of untouchability is profound, casting a long shadow on the lives of many. Its effects ripple through generations, marking individuals and communities in ways that are difficult to erase. The fight against untouchability is not merely a legal battle, but a moral and social one. It's about dismantling deep-seated prejudices and fostering respect for all human beings. The fight against untouchability, hence, is a fight for a more equal society,